Hello, everyone. I am Chase Allis, Program Officer with ACRL, and thank you for joining us for this ACRL Presents webcast, Digging for Gold with Bundles of Sticks, Copyright, Fair Use, and Text Data Mining, offered today as part of Fair Use Week. As a reminder, today's session is being recorded, and we'll share the recording link after the webcast. Our presenter today is Rachel Sandberg. Rachel leads UC Berkeley Library's Office of Scholarly Communication Services. A Duke Law graduate, Rachel practiced intellectual property litigation at Fenwick & West LLP for 7 years before spending 6 years at Stanford Law School's library, where she was head of reference and instructional services and a lecturer in law. She joined UC Berkeley in 2016, and now Rachel speaks throughout the country about copyright and scholarly communication issues, and is a presenter for ACRL's Scholarly Communication Roadshow. Her forthcoming chapter, Law and Literacy in Non-Consumptive Text Mining, Guiding Researchers Through the Landscape of Computational Text Analysis, will be published in the forthcoming Copyright Conversations from ACRL later this year. As a reminder, if you have any questions during the webcast, please enter them into the chat, and we will answer them following Rachel's presentation. Thanks again for joining us, and Rachel, whenever you're ready, the floor is yours.
Okay, great. Hi, everyone. Welcome. I'm really excited to be here with you today. I wanted to actually start by explaining why we are talking about text data mining in Fair Use Week. And it started because we were getting a lot of text and data mining questions here at UC Berkeley, and we were looking at some of the guidance that was being put out there by our campus partners. Our researchers were scared about the copyright law limits of what they could do, and we knew we could do a better job of communicating useful information to them about text and data mining practices and opportunities to use copyright protected materials, which they were avoiding working with out of fear. So as Chase mentioned, we worked on a chapter for a copyright literacies book. The chapter got some attention from other institutions and an Institute of Museum and Library Services forum, which morphed into the work that we're doing now on a possible NEH grant to hopefully create a training institute for researchers and librarians around all of these issues. Our overall goal is to ensure that any librarian who supports researchers conducting text and data mining feels confident in their ability to issue spot and suggest solutions and ask for more help for specialized issues. So today we're going to overview how copyright law fits in with text and data mining, the scope of fair use rights and what courts have said about it, and tips for building copyright literacy into text and data mining support and content licensing. We'll also highlight several other law and policy literacies that are important in this process, understanding of contracts, privacy, and ethics that also shape text and data mining research. But this will be just as a preview for our holistic text and data mining legal literacies training, which we offer here already on the UC Berkeley campus and also offer through ACRL's Scholarly Communication Roadshow. So you'll get just a taste of these other literacies as well. So let's take a look at an example of some of the kinds of problems that text and data mining scholars face. In this case, a researcher scraped rap lyrics from lyrics websites to download all of the song lyrics, which he then ran algorithms on to identify all of the unique words used. And then he sorted the artists by the number of unique words they used, which he called the breadth of each artist's vocabulary. It's just one example of how researchers are turning content, in this case the lyrics, into data, or here the number of unique words, by using automated techniques to extract metadata. Essentially, they're creating facts about the content that we license or that they find online. But scholars, and we as libraries in supporting them, face questions about rights in the text and data mining process. So if you follow some of this Twitter thread, you'll see that the authors happily deposited their code on GitHub, but they declined a commenter's request to share their scraping methodologies or the body of lyrics that they actually downloaded when they scraped. And it's not hard to see why, because by scraping and downloading the lyrics, they were making copies of the lyrics, and reproduction is a protected right under copyright. The researcher may have been uncertain about whether the fair use exception provided an ability to conduct this work. They may have also been concerned that the way they scraped violated the lyrics website's terms of use, however enforceable those may be, as we'll discuss today. And the researcher may not want to advertise to the world that they were violating those website terms. And finally, sharing the corpus or the body of collected lyrics that they scraped and downloaded with others so that others could run their own searches or test the algorithms they used would have been another republication of content, and again, a right protected by copyright. So fair use questions emerge again. But doing what this researcher did may have been exactly what the law allows, and his decisions around risk were likely appropriate. I want to underscore that the framing for this webinar is to help people understand what researchers can do to empower librarians with knowledge to support researchers in exercising rights and making fair uses, an exception that covers and authorizes much of text and data mining. We also want to empower libraries to enter contractual arrangements that maximize text mining uses. So naturally, we'll discuss today some legal boundaries, but this isn't an exercise in saying no, rather in showing how many ways there are to get to yes. So let's start by relying on a working definition of text and data mining, since it will help us better understand what the legal issues are that emerge. We like this definition from Ann Okerson, which says essentially that text and data mining is the use of automated tools and techniques to process large volumes of often unstructured content to extract information and relationships about and between the content. So note the emphasis on automated extraction of information from digital content to show relationships between or information about the content. As we'll see, this is key for why text and data mining is such a good fit for fair use. To really understand text mining under the law, it helps to understand both the purpose and methodologies for text mining, so we can see how it intersects with law and policy. For instance, University of Illinois is home to a collaboration of social scientists, humanities scholars, and digital researchers who hope to harness the power of high-performance computing to find and understand the historical experiences of Black women by searching two massive databases, JSTOR and HathiTrust, of written works from the 18th through 20th centuries. They worked with 800,000 periodicals in JSTOR and HathiTrust from 1746 to 2014 to identify the types of conversations that emerge about Black women's shared experience over time and the resulting knowledge that developed. They used data visualization techniques such as tree maps to identify spikes in certain topics during various historical contexts such as slavery, Reconstruction, and the Jim Crow era. You can also take a look at a collection of digitized versions of Jane Austen novels that you can work with to run tests for sentiment analysis. Sentiment analysis is the process of computationally identifying and categorizing opinions expressed in a piece of text, especially in order to determine whether the writer's attitude towards a particular topic is positive, negative, or neutral. So you can mine Jane Austen's work as we speak for determining anything around sentiment analysis, such as how she defines gender roles, how women are referenced as feeling things where men are referenced as knowing things. Based on our understanding of projects like those I just mentioned, like Jane Austen's and the one at the University of Illinois, and even the rap lyrics example, as well as our understanding of what researchers are trying to do with text and data mining, we've distilled a set of legal literacies or competencies that can help you advise researchers with text and data mining projects from start to finish, from how they access materials to how and where they publish their results or the materials that they collected to work on, which are sometimes referred to as a corpus or corpora in plural. So these literacies that we have identified are copyright, contracts, privacy, ethics, and other statutes and use cases. We're going to have time to focus only on a few of these literacies today to highlight how they intersect with Fair Use Week. So we'll be looking at copyright, contracts, and other statutes or use cases. Each of these three literacies involves copyright law, so it fits perfectly with what we're doing today. So let's start with copyright. As many of you know, because I looked at the attendees list, copyright is a question of federal law. And when we say copyright, we refer to a collection of statutory provisions within Title 17 of the U.S. Code. Congress was directed to create these laws by the Constitution, which asked Congress to create laws to encourage progress in the arts and sciences by rewarding authors with exclusive rights to their writings for a limited period of time. The Constitution's framers limited the time because if the rights lasted indefinitely, other people wouldn't be able to use the materials to build upon and advance the progress of science. So Congress enacted copyright statutes that give the creator of original expression a set of exclusive rights to their works, but only for a set period of time. So what are these exclusive rights? Well, they're often referred to as a bundle or a bundle of sticks of the following rights. Let's say I've written a novel. As the author or creator of this original work of expression, I have the following exclusive rights. I can make reproductions or copies of that novel, so I can upload it to a website and download it as many times as I want, print out copies and photocopy them. I have the right to reproduce my novel. I can also make exclusively what are called derivative works, which are follow-on adaptations of the original creation. So for example, with this novel, if I've found a few errors or I want to change the ending, I can publish a later edition that revises my work, or I could make a movie adaptation of my novel, or I could create an interpretive dance based on the novel. These are all of my rights because I am the author, assuming, of course, that I have not assigned all of my rights away to whoever publishes my novel. I can also distribute copies of my novel. So again, assuming I haven't passed these rights along to anyone else, I can make all of you attending here copies of my novel. I can publicly perform it. I can get into a room and charge admission for you to hear me read my novel out loud, because I'm sure that's exactly what you would want to do. And I can publicly display it. So I can print out large copies of every single page of that novel and publicly display it for everyone to see. Those are my exclusive rights as the author of original expression. So if authors have these exclusive rights, then how can our text and data mining researchers scrape, download, reproduce, or publish work that's subject to copyright? Well, as a preliminary matter, for material that has entered what's called the public domain, there aren't any copyright protections. So many text and data mining researchers choose to work with public domain corpora so that they don't have to deal with copyright issues to begin with. Public domain materials include materials for which copyright protection, meaning the limited times for which it lasts, has expired. While the length of protection varies by the nature of the author, corporate versus personal, for instance, the modern length of protection in the United States is typically at least the author's life plus 70 years after the author's death. We're now at the point that materials published in the United States in 1923 or before have all entered the public domain. In addition, public domain materials include U.S. federal government works, like this Centers for Disease Control article about hedgehogs, which I'm sure everyone wants to mine for sentiment analysis. Another way that text and data mining researchers seek to avoid dealing with copyright questions is just by working with facts. Copyright protects creative expression, not facts. So for instance, researchers just seeking to mine information about statistics or citations and then mapping information about who gets cited and where and how are not using any content with expressive elements. That is, the content they're using isn't protected by copyright to begin with because citations are just facts. So these text and data mining researchers also don't have to worry about copyright constraints. One of the things that we've been focusing on in our development of legal literacies for text and data mining is that if researchers are only working with public domain materials or with works that aren't protected by copyright to begin with, this artificially limits the scope of what they can analyze. We want text and data mining researchers to understand that it is perfectly fine to work with copyrighted content. Text and data mining is unique among other types of research in that it enables a very strong fair use argument for working with copyright protected material. So here's what I mean. Imagine the scholar on the left is reading a collection of post-World War II poems to analyze themes. And imagine her colleagues on the right want to analyze linguistic trends in the same collection, not by reading the poems, but by extracting data like word frequencies or language choice. In order for her text and data mining colleagues to develop a sufficient poetry collection for reliable and thorough analysis, they've got to download poems from various sources en masse to perform computations on them. They are in essence converting masses of text into metadata. In turning text into metadata from a copyright perspective, the researchers need to download poems, and this makes digital reproductions. And as we saw earlier, reproduction is a right that is held exclusively by the copyright holder. But what the text and data mining researchers are doing may fit within an exception to copyright law called fair use because it's very transformative. So let's dig into what fair use is and why it strongly supports text and data mining. Fair use is an exception built into the copyright statutes and appearing as Section 107 in Title 17 of the U.S. Code. It was meant to encourage uses of copyrighted work in order for people to engage in criticism, comment, news reporting, teaching, scholarship, or research. So by its nature, the fair use exception applies to the very kind of work our scholars are doing in exposing relationships or information within or between content. Section 107 goes on to suggest 4 factors that courts should balance or consider when determining whether a use is fair. You may have heard this as the 4-factor balancing test. So the problem is with a 4-factor balancing test is that you'll never know if you were right in balancing the 4 factors unless the matter goes to court and a court agrees with you. But what researchers need to consider are the following 4 factors in determining whether their use is fair. First, the purpose and character of their use. In this case, you'll look to whether you're using something for nonprofit educational purposes or in the context of for-profit work. And what courts really look to here is the purpose, whether the purpose of what you're doing and how you're working with the material transforms from the original purpose that the author intended in creating the work. So in the case of text and data mining, we can imagine the work was originally created to be read. If you are now extracting information about the content, that's a very different purpose from what the author originally intended in writing a book, for example. I think it'd be helpful here if we actually think about potentially saying that I have a bunch of Stephen King novels that I have in print, that I previously purchased in print, and I'm now digitizing them because I want to understand what language he uses to indicate or to create suspense. So if I'm extracting that kind of information from these Stephen King novels, I'm doing so for a very different purpose from what Stephen King intended in writing the novels. We should also look to the nature of the copyrighted work, whether it's factual or scholarly. And unfortunately here in the case of these Stephen King novels, these are highly creative work, right? So they're more likely to be strongly protected by copyright as opposed to, say, a factual scientific article. The problem is courts don't like to be in the business of assessing how factual or scholarly versus how creative and artistic something is. So they tend to de-emphasize this second factor, even though it's a 4-factor balancing test and everything must be considered. They tend to place less importance on factor number 2. But for purposes of what we're doing here, let's just say that factor 2 weighs against us because I'm working with highly creative work. Courts will also look to the amount and substantiality of what I'm using relative to the entire work. Am I using a large amount or the most important amount of the work in order to perform my research? And again, in the case of text and data mining, we actually need to use the entire book in order to figure out how many times a certain word was used or how many or the way that sentiment is expressed. So I would say that factor 3 also weighs against a finding of fair use. But in this case, factor 1 was so strong in the transformative nature of what I'm doing that potentially overall things could still be fair. And finally, what is the effect on the potential market for sales or licensing of the original books. We are looking at not just whether or not I'm affecting Stephen King's ability to sell his books, or frankly his publishers because they hold the copyright, but whether my use is supplanting the market for selling those books. And if I have purchased all of these books and I'm digitizing them to run sentiment analysis on them, I'm not interfering with Stephen King's ability to sell his books to me or other people. Arguably, anyone else who wants to actually read the book to know what it says still needs to buy it. So overall, you can see that factors 1 on transformativeness and 4 related to the potential market for the original tend to factor in very strongly in favor of fair use for text and data mining. And we'll look first at 2 of the leading cases that have addressed this issue. They both relate to Google Books' practice of scanning library books and making them available either through HathiTrust or through Google Books for certain types of textual searching. So with HathiTrust, the books were made available in the HathiTrust digital library only for purposes of being able to identify where certain terms appeared. So you could enter a certain term in HathiTrust digital library and get a report like that on the right, which shows the pages on which those terms appear and the number of occurrences of the terms on those pages. The court found that for the same reasons we just discussed with the Stephen King books, when you are taking content and making it available to mine it for things like the number of occurrences of words or sentiment analysis, that is for a very different purpose than the author originally intended in writing that work to be read. What we're doing as researchers is not consuming the work, but rather finding out information or metadata about the work. And so that was highly transformative, so transformative that the overall use was fair. In the Google Books case in 2015, in that instance, the court examined whether or not Google's display of snippets from the books that were digitized, which are no more than around 3 lines, constituted a fair use, given that the researchers or anyone searching within the books could actually see a little bit of the book if they were searching for particular words. They were also looking at Google's use of the Ngram viewer, which allowed researchers to search for a string of words to see where those appear in a book, and again, potentially showing them in a snippet view. And the court found the same thing as in the HathiTrust case. What readers are actually able to see is not a substitute for having to purchase the original book. If you are looking within these materials that Google has made available to you for the occurrence of certain words or terms, you are not going to use that as a substitute for having to purchase the original if you actually want to read the book. That's why Google only shows you a snippet view of what you've searched for. Now, of course, arguably, if Google's systems were hacked or HathiTrust systems were hacked and all of the scanned content were made available for anyone to actually read the full text, then potentially on the 4th factor, you would be cutting into the market for selling or licensing the original. However, the security protections were in place in both of those cases, and the court didn't recognize that there was a credible security threat. One last example of how the courts have looked at fair use in text and data mining comes with the Turnitin software, which is a plagiarism detector. In this case, several high school students sued iParadigms, arguing that the copying of their high school term papers into Turnitin so that teachers could determine whether or not, using the software, whether or not the students had plagiarized other students was the court determined that this was a fair use for similar reasons that we just looked at with the Google Books and the HathiTrust cases. The iParadigms was replicating the content not for those term papers to be read, but for the software to be able to detect similarities between the papers. In addition, the court, which was very transformative, and in addition, the court noted that there is not really a market for selling high school term papers, so it was not actually supplanting the market for anything. But if we know that text and data mining researchers can use copyrighted content, why does the HathiTrust Research Center put it behind a wall, leaving researchers only to determine things like word counts, or allow use of the content itself only in data capsules where you can query other patterns but can't see the actual text? If you can work with copyrighted content under the fair use exception, why are Google Books not viewable? Why are researchers left to work with only strings of words to test when they might need longer consecutive word strings or paragraphs? Because what might be fair use for research might not be if you're then publishing what you've downloaded and created to text mine. There's a difference between creating your own database to work with the copyrighted content for your own personal research and then sharing that corpus itself, even if it's annotated, for others to see. Of course, researchers may have a strong desire to share all of the things they've downloaded to help other researchers answer different questions or to test the validity of the algorithms that the researcher is putting forth. But it is the republication of content that could tip the balance against fair use. Suddenly, publishing digital versions of Stephen King's books so that other people can ask different questions about the books could indeed supplant the market for other people having to purchase or license the original, which is fair use factor 4. It can now also be consumed in ways that are no longer transformative. That is, other people could simply read the texts for their expressive qualities, for the reason that Stephen originally wrote the books, which is fair use factor 1. We saw this exact boundary recently with the TVI's case. TVI's coded Fox News clips by topic so that TVI subscribers could search for specific relevant content by issue. But then TVI's also allowed its subscribers to view and share 10-minute clips of that relevant Fox News content. The court found that while keyword-enabled searching would be both transformative and a fair use overall for some of the reasons we've just looked at, it was the permitting the redistribution that rendered it unfair because it made available to TVI's clients virtually all of Fox's copyrighted content that the clients wished to see, and because it deprived Fox of revenue. Of course, this case was in a commercial context, so of course, use is less likely to be fair under Factor 1, and thus there are limits to how applicable this case should be to scholarly situations. But the lesson about concern for the amount that gets republished, I think, is clear. Researchers need to think about how much of the original content that they've mined and they now want to include in a journal article or other scholarship or databases that they're publishing, and how they want to share their data. For instance, are they sharing all of the content they downloaded merely with annotations, or are they sharing a derived data set based upon it that does not actually republish the content itself? So the takeaways I'd say are that it's likely fair to digitize to conduct text and data mining, provided that you have the security precautions about not having all of the material loosely available online for downloading. But it may not be fair to republish large portions of the content or to circulate the digitized texts or corpus. Of course, you've got to look at it on a case-by-case basis and see the context in which researchers are working. But what might be fair for research might not if you're republishing what you've downloaded and created. Another literacy that's important for librarians to understand relates to various types of contracts that either libraries sign or that researchers enter into that could affect the text and data mining research being conducted. And as I said, we're going to look at some copyright overlaps with these agreements. For instance, are researchers using materials from a museum or library's archives? Are they using materials that are already digitized on a website or from within licensed databases. These types of agreements can expressly supersede copyright. That is, they can curtail uses that would otherwise be permitted because the material is in the public domain or it would have been fair use. We all know that content vendors often attempt to control through contracts what they can't control through copyright. Many of you are probably aware of this already in your own libraries, that you have many databases that have material in them that is obviously in the public domain, but the terms of our licensing agreements with the database restrict what users can actually do with the content. So let's go through the types of contracts that can affect researchers conducting text and data mining. First up, the database agreements that libraries sign. These can affect researchers' ability to make text and data mining uses of the material, whether on the access side of things by limiting researchers' rights to make downloads, or on the republishing side of things by restricting circulation of the content. If scholars are accessing material from library databases, our database agreement applies to them, even if the scholars didn't sign anything themselves. Making matters more challenging is the fact that researchers can have a difficult time finding the terms of our database agreements, as the agreements we've signed are typically different from any public version viewable on the publisher's website. There are very few institutions that do a great job of providing visibility into the terms of all of their agreements. At Berkeley, we do have a page listing some of our agreements that expressly allow text and data mining, but otherwise people need to contact us and ask us what our agreements provide. And we have an email address set up for that. A second type of agreement that text and data mining researchers encounter is one offered by a museum or archive that holds the collection of materials that the researcher is seeking to use or to digitize. Here we see an archives agreement, and I'm not going to shame the name of the archives because unfortunately we're in a similar situation here and one that I'm working on. So we're just going to look at the terms themselves. But here we see an archives agreement that requires library permission to use any materials from the archive, even if, as we know, it would be fair use under copyright law to do so, and even if the library or archive is not actually the copyright holder to begin with. In this case, the researcher is then also required to contact the copyright holder and ask for permission, again, even if it would have been fair use to publish. So this puts researchers in a position of having to ask for permission both of the library and the copyright holder, when in both cases it could have been fair use to work with and publish the materials. This is a poor practice, but the good news is that these agreements with memory institutions are often more negotiable than they are with vendors. Finally, another contract that researchers encounter is a website's terms of use if the researcher is getting content online and not from our databases. Websites may have terms of use that are considered browse wrap agreements, meaning users consent to them simply by browsing the site. Typically, our researchers want to scrape everything they find online. The scraping can be a violation of these types of terms of use, which require permission before reproductions or downloads can be made. For instance, here's one from a memory institution in Texas, and that's as far as I'll go, indicating that users must ask them for permission to reproduce images, potentially including downloading them for text and data mining, which, as we know, creates a digital reproduction. Again, even if doing so would constitute fair use. Now, browse wrap agreements like this are not always enforceable by a court. Contract issues are questions of state rather than federal law, so courts in different jurisdictions may require that users have either actual or constructive notice of these terms and conditions. Constructive notice meaning should a reasonable person have been aware of the terms based on how the website was presented. Constructive notice courts will look to things like how visible the terms of service were and whether the users were affirmatively asked to consent to them, which would constitute actual knowledge. But other courts simply find these types of browse wrap agreements enforceable. So what should we tell our researchers? Well, best practices are that they should be aware that these terms may exist and make risk calculations accordingly. Often, if they are just accessing publicly available content, and downloading it just to scrape without breaking behind walls to get at the content, then it could potentially be low risk to violate these terms because it may be hard for the content owner to prove damages. In other words, what did the website's owner actually suffer if its publicly available content was used for textual analysis? But that doesn't mean they won't sue to try to prove damages. As libraries, we can do a better job of having our agreements not override text and data mining and fair use rights. Fortunately, within the University of California system, California Digital Libraries model license protects text and data mining uses. So let's look at why it's so favorable. It says that authorized users, meaning people, let's say at Berkeley, who have a right to use our licensed content, let's say because they're students, can do so to perform text and data mining if they're engaging in academic research, scholarship, or other educational purposes, and can share the results of their text and data mining as long as they don't substitute whatever they publish doesn't substitute for the original licensed material. So you can see that this is essentially trying to recreate what fair use already allows by expressing an expressed term related to text and data mining, used in research, scholarship, and educational purposes, as long as it's not a substitute for the original materials like we would have seen in Factor 4 of the fair use test. There's another way that we can ensure preservation of text and data mining for our researchers, though, which is to include what's called a fair use savings clause. So here, including this clause, which says, notwithstanding whatever the rest of this agreement said, we should not read this agreement or anything in this agreement to otherwise restrict uses of the material that would be fair pursuant to Section 107, the fair use exception in the Copyright Act. This is important given that courts have found that downloading to conduct text and data mining constitutes fair use. So if we expressly preserve fair use with a clause like this, in turn, we are preserving text and data mining because courts have found that to be a fair use. As I mentioned, unfortunately, we don't really have time today to cover in depth some of the other legal literacies necessary for text and data mining. And of course, then we would start to drift beyond the focus of Fair Use Week, even though I'm very passionate about all of these other literacies as well. But since the other statutes literacies do raise some copyright-related concerns, I want to at least give you just a glimpse of one more literacy. The Computer Fraud and Abuse Act is an entirely separate statute from copyright or from any state contract statutes. It's actually a federal criminal statute, that is a federal crime that deals with unauthorized network access. The good news is that it usually only comes into play if someone's trying to get behind a firewall or protective measure of some sort and, for instance, scrape or download content. But if our researchers are not circumventing protection measures to gain access to the content, if instead all they're doing is just using a database that they have access to from us or through a public website, then even if they download material in violation of the contract, in violation of the license agreement or the terms of use, it is just a violation of the contract, not a federal crime under the Computer Fraud and Abuse Act. It's only when a researcher tries to sidestep access measures to gain access to a computer or network to get information they shouldn't otherwise have access to that the Computer Fraud and Abuse Act comes into play. Another relevant statute is the Digital Millennium Copyright Act, which is a collection of statutes within Title 17 of the U.S. Code where the copyright statutes live. Now, Section 512 of the Digital Millennium Copyright Act prohibits the circumvention of technological measures to gain access to copyrighted content. DVDs are an example of the kinds of materials that contain these technological protections. If a researcher wanted to download portions of a DVD for use in text and data mining research, and not for short clips for the classroom, for which there actually is an exemption, this could violate the Digital Millennium Copyright Act. However, this is where having some legal literacy on these points is key. The DMCA prevents breaking technological measures in the DVD. It's not a circumvention of the technology, to use screen capture to record what's playing on your computer. You're not hacking the DVD, just recording what you see. Of course, you are copying copyrighted content, but this is where a researcher would make a fair use decision. I can give you a good example of this coming to play in real life. So actually, the reason why I got started working on text and data mining legal literacies for scholars is because I was approached by a faculty member here who was interested in studying whether or not he could use algorithms to predict when laughter would occur in sitcoms. Now, in order to be able to predict whether or not he's right about when laughter occurs, he needs access to the actual video and audio footage from the sitcom. And in many cases, those sitcoms are available either through a license agreement, let's say through iTunes, or from a DVD which has those sitcoms on it. And so he came to me knowing a little bit about copyright law and asked whether or not he could circumvent the measures on the DVD in order to get the underlying content so that he could then run his predictive algorithms on it. And so we were able to talk through how the Digital Millennium Copyright Act could interact with the work that he was trying to do and explore other alternatives like screen capture, which would allow him to get the same information without breaking technological measures on the DVD itself. Now, lastly, I'll mention some other use cases that fall into this other statutes, other use cases bucket that, again, we don't have time to really explore in depth today. But let's imagine that you have scholars who are working with other researchers overseas, and either the collection that they're looking to work with is held there, or there are licensing agreements for that material that are held from your collaborators and through your collaborators' institution. There can be all sorts of questions around whose copyright law actually applies and whose contract law actually applies to these kinds of collaborations. There are also instances in which the work that we do with our collaborators abroad might implicate the moral rights in copyrighted content for material that is published abroad. So unlike US copyright law, a lot of other countries' copyright laws offers the owner or the author of the material to hold rights in how that material is used as a reflection on the integrity of the author, him or herself. So answering these kinds of cross-boundary questions can be really important. Again, it's a special use case which doesn't necessarily come up all the time, but this is where kind of working, or I will say this is where taking kind of the full version of these trainings could be really helpful. So I would encourage those of you who are interested to reach out to me. I'm happy to share the work that we're doing, the full version of this, along with all of the associated exercises we do in class, or to apply for an ACRL roadshow. Scholarly communication from understanding to engagement, you could choose text and data mining literacies as one of the modules. And as I mentioned earlier, hopefully all of this work that we're doing will receive a grant, fingers crossed, from the NEH, so that we can actually hold an institute to train librarians and researchers in a more in-depth setting around all of these issues. So I think I've done really well trying to leave 15 minutes for questions at the end. So I'm going to exit from the presentation, and I will stop sharing my screen if I can, let's see, figure out how. Let's see, share my screen no longer. I think that's right. So can you guys see my screen anymore? You can't. Chase, can you hear me?
Yeah, I can hear you. Your screen is still up.
Let's see. Oh, stop sharing. Here we go.
Perfect. There you go. Thanks, folks. As Rachel said, we can take questions now. So if you have any, feel free to put them in the chat box. And if you are not seeing the chat box, if you hover over your screen towards the bottom, you'll see several icons probably, and there's a little chat bubble one. So if you click on that one, you can see the chat, and then put your questions in. We'll be happy to take those. Thank you. All right, Rachel, looks like we have our first question. Are there different types of DRM on UK music CDs?
You mean are the actual technological measures that they put on the CDs or DVDs, they're a different form from the DVDs here? Is that what the question was?
This is from Gwen. I think she'll have to elaborate on that. That was the full question.
Okay, yes, but for me, okay. I'm not actually sure how they encode other content. I mean, the reality is that there is not currently an exception in the Digital Millennium Copyright Act that expressly authorizes breaking the technological measures to conduct text and data mining. Now, this is actually something that is part of the work that I mentioned we're doing. We are looking to raise to the Copyright Office in the next round of comments for potential exceptions, which is coming up in about 2.5 years. So this is work that our office and the Samuelson Clinic and Authors Alliance is going to be taking on to actually attempt to create an express exemption in the Digital Millennium Copyright Act to authorize breaking the technological measures, whether it's in DVDs or even, let's say, ebooks, specifically to conduct text and data mining.
Okay, Rachel, we have another one from Rick. If you're trying to create a corpus of video content using screen capture, don't you have to view each recording in real time? This seems very limiting if you want to build a large research corpus. Do you have any suggestions re legal workarounds?
Well, again, as I mentioned, I mean, you could. There's no current statute that, I mean, there's no current exception in the Digital Millennium Copyright Act that authorizes breaking these measures for purposes of text and data mining. You could endeavor to use automated techniques, and this is actually what our scholar did. The screen capture software downloaded all of, or captured all of the content, and I think he did so in some kind of accelerated form. The researchers weren't sitting around trying to capture it, but I take your point that if there's a large volume of content, that it could be timely to create the corpus itself. I don't know how different that is from creating any other kind of corpus. I'm sorry, that's probably a very unsatisfying answer.
All right, Rachel, next one is from Carmen. Rachel, thank you for such a great presentation. I have a faculty member who would like to mine a set of 7 contemporary novels published in Germany. What guidance can you give me in exploring whether or not we can do this?
Great. So because of the bilateral agreements that we have signed, if those novels were published in Germany and your researcher is doing the work here in the United States, then U.S. law is going to apply to the work that he or she is doing. So I would say the best practice is for the researcher to digitize them here and to extract whatever they want to extract. But then again, because we know that this to be fair use, but then what the researcher chooses to publish, whether in the journal article he or she is writing or of a derived data set, should not include large portions of the actual content. They shouldn't share those digitized texts for example, with others to run their own queries on.
Okay, the next one is from Colleen. Do you have any recommendations for how librarians who are not the ones in charge of handling database contracts can read, access, and understand restrictions on usage for downloading and mining articles? Any online resources we can use as librarians to quickly see what contracts allow?
Great question. Two things I would suggest right now. One is to look at the resources that California Digital Library puts online, which explain what their model terms are, so that you could look to, compare your agreement with what California Digital Library recommends, because I think that will make it easier to understand what your provisions allow. I'll also say that Authors Alliance recently put out a book on understanding publishing contracts. Now, these are about publishing contracts for monographs or for books, but the way that they help you understand the provisions in them can still be applicable to databases as well. I am sure that there are other resources that might be helpful, and I'm just not, they don't come to the top of my mind right now.
Okay, the next one is from Susan. Although U.S. copyright doesn't deal with the moral value of the creator, if the copyright owner or author perceives the text mining as detrimental to their image, is there fair use protection against the claim?
Yes. So again, if we're talking about work that's being conducted in the United States, I can be very unhappy as an author with someone extracting a bunch of information from, let's say, everything I've read or I've written, and using that to show, maybe I keep contradicting myself, and that can be very embarrassing to me, and I might want to put a stop to that because I think that it's detrimental to my image. But U.S. law doesn't protect my ability to do that. If what was being published were false, then potentially there's a defamation claim, for putting me in a false light or for making false representations. But from a copyright perspective, their right to mine what I've created, as long as they're not republishing the content itself, which can exceed fair use, they have a fair right use to do it.
Okay, thanks for answering all these questions, Rachel. The next one is from Lynn. I'm sorry, Lynn, if I'm mispronouncing your name, or Linny. To avoid reproduction, could TDM researchers or text data mining researchers share their feature representations or only share their programming algorithms for how they got to scrape text?
So it is perfectly fine. So they can share algorithms, no problem. It's also, you can also show, and in many cases, you need to show excerpts of what you've done, or like images of how of what you've been working with, in order to show how your methods, how your algorithm functioned, for example. It comes down to how much you choose to display of the original content, and this is the question about maybe showing a paragraph or some kind of image to explain how your methods worked would be fair use, but when you look at sharing a much larger portion, then at some point you're going to hit the bounds of fair use. And I'll also say that one thing, it sounds like you already know, one thing that researchers usually can choose to do is share derived data sets, or to share visualizations that they've created based on the data. Showing visualizations based on the data they've extracted does not reveal any expressive qualities about the original content itself.
Okay, and then the next one we have is from Susan. Could you speak to the issue of controlled digital lending?
Yeah, so that's not, I'm going to try to also tie that into text and data mining, since controlled digital lending can be its own thing as well. So for those who aren't familiar with this, controlled digital lending is the idea that if we've purchased a print copy of a book, then it's fair use for us to digitize that and make that available for lending as a library under the same terms and conditions that the original print version would have been made available. So if we have one print version of a book, we can make a digital version available for one user to check out, and we lock down the original print version while the digital version is checked out. And the person would be able to check it out for under the same terms and conditions that they would be able to with the print version, and that this is fair use. This really, as you probably know in asking this question, this has not yet been tested. This theory that controlled digital lending is fair use has not yet been tested by the courts. But where text and data mining comes in, I think, anyway, one way text and data mining comes in is that what we might not be able to do with controlled digital lending is digitize the book in a way that allows text and data mining of our digitized version. Because in that scenario, it's not really the same terms and conditions that a user would be able to make use of the book as with the original print. In that scenario, they could actually, it's a much more enhanced version that they can work with, and that might cut into, let's say, if the publisher of the book were already making digital versions available, which could be used for text and data mining, then potentially what we're doing supplants the market for the publisher. And so potentially text and data mining could exceed fair use if we were to make our controlled digital lending versions available for it.
Okay, thanks everyone for your great questions. We might have time for one more very quick one. We just have a couple minutes left, and I don't want to keep everyone over. And Rachel, thanks so much for your great presentation and for answering all these really great questions as well. Oh, looks like we have one more. For cross-border, if one scholar doesn't have license from their library to use corpus, could they be shared?
For cross-border, if one scholar doesn't have a license, okay, so what it's going to come down to is what the terms of the license agreement actually say. So if we're working with scholars at a different institution, and the scholar who does have access wants to share those materials with researchers at other institutions, that scholar with access actually needs to look at what the terms of their license agreement say about sharing with research collaborators.
Perfect. Thanks so much, Rachel. And just a little plug, if you would like a deeper dive in person into copyright or other scholarly communication issues, then, or if you want Rachel to come to your campus and teach you all, we have a scholarly communication roadshow that she is a part of, and I can put the link to that in the chat box. Oh, and sorry, question from Carmen. Will I be able to share an archived copy of this webcast with faculty? Yes, we will have this publicly available on ACRL's website, and then you can share that freely as you would like. And then I will put the link to our scholarly communication roadshow workshop up in the chat box in just a second.
And I'm also, Chase, I'm also happy to share a PDF of all of my slides if anyone wants to use them or do anything they want with them.
Yeah, that's great, and we can put that on the website as well. So that would be great.
Okay, you can probably hear the Berkeley bells chiming, so I know we're at noon.
All right, everyone. Well, thank you so much for attending, and we hope you enjoyed this webcast. And thank you to Rachel for her great presentation. And we will send out the link probably in the next day or two. We'll make that available to the public. So thank you all.
All right, thanks, everyone. Bye.